Welcome to this channel. Hope you all are doing great in your life. Today we'll discuss a new topic, the relation between the international law and the municipal law. Introduction. International law and the municipal law is the outer and inner part of the legalism to a sovereign state. Before going in detail, I think it is important for one to have a basic understanding what is international law and the municipal law. International law is a body or set of rules established by customs or treaties, which is the binding force to maintain the relation between the nation state. Municipal law, in an easy way to say, it is a national law. It deals with the internal matter of the state, such as crime, property, federal relation, and many more. Now the question stands how the correlation mingle between the two, where the international law focuses on the interstate relation and municipal law between the state and its citizens. These are the two different legal system or order in concept. I will obviously request my viewers to watch the video on international law, which is already uploaded in the introductory playlist, and its link is given in the description box. Please watch that video for the better understanding. Discussion. The relation between the international law and the municipal law are based on some theories. Monistic theory, delegation theory, dualistic theory, specific adaptation theory or transformation theory, and harmonization theory. Monistic theory. The chief exponent of this theory were Moser, Hegel, Zorn, Wright, Kelsen, and others. To this theory, international laws and the municipal laws are the one aspect of the one system. Kelsen asserts manifestation of single unit of law. Kelsen further states one can conceive of international law together with the state legal system as a unified system of norms in exactly the same way as one is accustomed to regarding the state legal system as a unity. The theorists of this school never viewed separate or detached the legal system, rather they viewed as manifestation. The theorists of this school believes that if any municipal law comes after the international law and the municipal law violates the principle as laid down in the international law, then such municipal law becomes void. To them, the international law prevails over the municipal law. Article 27 of the Vienna Convention speaks on the law of treaties, that when there is a conflict between the treaty and the municipal law, the state must follow the obligations under the treaty. Delegation theory. It is the ahead theory of the monistic approach. The idea behind the theory is that the application of the international law in the national law can be done through the process of delegation. Thereby, both the legal system club into one system or order. Dualistic theory. The chief exponent of this theory were Hirsch, Lauterpacht, and Trippel. The theorists believed that the international law and the municipal law are two different legal systems or order. To support their claim, they pointed out that municipal law are the outcome of the enactment by the sovereign state authority for the citizen, whereas the international laws are mutual agree relation between the states, as the municipal law are authoritative over its territorial and citizen, not so in case of between the states, that is international law. The source of these laws are different. Each is supreme in its own domain. International law cannot interfere with the municipal law unless the same is incorporated in the municipal law. McDougall asserted, the dualistic exhibits as their most distinctive characteristics an attempt to rigidity, the fluid process of world power interaction into two absolutely distinct and separate system or public orders, and one international law and the other national law. Each system is thus alleged to have its own distinguishable and subjects, distinguishable substantive content. The subject of the international law are said to be state only, while those national law embrace individuals and a whole host of private associations. Specific adaptation theory or transformation theory. This theory is based on the dualistic theory approach. This theory explains that there cannot be direct application of the international law in the sphere of municipal law unless the specific international law is adopted in the municipal law. Such adoption must be absorbed by the municipal courts and system. Harmonization theory. The chief exponent of this theory were Rousseau and Fiznourica. The approach of the theories differ from the monistic and dualistic approach. This theory conveys that each law is supreme in its own system or order or domain. This theory viewed that if there is a conflict between the two, then the international law will get its application in the discharge of the state's obligation, whereas the municipal law will find its application in the internal jurisdiction. The exponent always suggested that the courts must try to minimize the difference in law of the both order in order to harmonize the both system of law. Earlier in the dualistic theory, we found that both the systems are anti to each other, and in monistic theory we learned that both the systems are same. But in this theory, we find the balancing of the both systems to maintain the harmonization. International law and many countries, US and UK. The classical doctrine of the English law deals with the relation of international law and the law of England. The British law generally follow the dualistic approach of international law. It accepts that municipal law and the international law operates on different strata. Customary international law are accepted by the English courts. It views customary international law as the part of the common law. The US Constitution have not expressly incorporated the international law. Like the England, the courts of US applies the customary international law. In Bush versus Barry, the US Supreme Court viewed that US has the interest in complying the international law. India. International law and the treaties has been dealt in the Indian Constitution under Article 51, 73, 245 and 246. But there is no clear guideline regarding the relationship between the international law and the municipal law in the Constitution. Clause C of the Article 51 speaks the term international law. India have the dualistic approach regarding the relationship. As to the aforesaid mentioned articles, the Indian courts can take into consideration for the application of the foreign laws if it is not contradicting with the municipal law. But in order to incorporate the foreign laws, the enactment is necessary. Where the municipal law is silent, the court can use the customary international law. Interpretation of this relationship by the Indian courts. In the case of Sri Krishna Sharma versus the state of West Bengal held, if there is a conflict between the statutory law of this land with that of the international law, then the municipal law will prevail. In PUCL versus Union of India, the petitioner approached the court in reference to the principle of human rights for the food. The court observed the principle of human rights and directed subsidized food grains for the poor. In Vellore Citizen Welfare Forum versus the Union of India, in this case, the court viewed that when the customary international law is not against the national law, then the court shall follow the international law. In another case, Jolly George Vargas versus the Bank of Cochin, the court observed that when the municipal law is silent on a particular issue, then the court can use the customary international law.